Hello, everyone. Welcome to today's Venable Nonprofit Organizations Group monthly webinar, Working with Influencers, Legal Essentials for Nonprofits. I'm George Constantine. I co-chair the Venable Nonprofit Organizations Practice Group along with Janice Ryan. I have the pleasure of introducing today's program, which I believe will help all of you understand how a nonprofit organization can work with influencers and content creators in furtherance of the organization's missions and goals, while being mindful of the very difficult and different compliance and other risks that can arise when doing so. We've got a great roster of speakers here who are going to contribute from different perspectives on this topic. But before I get into introducing our speakers, just quickly wanted to let you know, please keep an eye out for an invite that should be coming soon for June's monthly webinar. We're going to be tackling some IP licensing issues for that one. We're still finalizing a date and time, but we'll be letting you know on that shortly. So keep your eye out for that. I will also note the slides that are being presented today and the recording of this webinar will be available to everyone after the webinar closes. Usually it's about a week or so. You'll get a notice by email that they're available and online for you to review. So I know that often comes up. So briefly on to today's speakers. My brief introductions here will probably not do justice to the tremendous backgrounds each of them have, but you're welcome to view their more comprehensive bios on our website. I'll start with Shahin. Shahin Rothermel is a partner here in the DC office, and she works in our nationally recognized advertising law group. She's worked closely with many of our nonprofit organization clients over the years, as well as other business entities on these very issues, and has extensive experience, not just in advising on compliance, but in helping with investigations and on litigation as well. So tremendous experience and perspective for today. David Owens is a counsel in our political law practice, and he advises a lot of our nonprofit organization clients. Many of you may recognize Dave or know him from advice that he's given to you over the years on complying with state and federal restrictions addressing political and lobbying activity. This being an election year and the importance and increasing popularity of using influencers and content creators for those purposes made us think that Dave would be a perfect addition to offer his perspective on that issue and from that front. And then finally, Cristina is a counsel here in our nonprofit organizations practice, and she advises our nonprofit clients on many of the typical issues that we always advise you on, matters related to governance, transactions, tax, related issues that many of our nonprofits confront on a regular basis. Most relevant for today's discussion, though, is Cristina is very much steeped in knowledge when it comes to charitable solicitation fundraising requirements and regulations, and will offer that perspective as part of the discussion today. That will conclude my introduction. I will turn it over to Cristina to get things started, and thank you again.
Thank you and welcome everyone. One final housekeeping point. For those of you that are watching today's presentation for CLE credit, we'll offer the code at about halfway mark and then again towards the end of the presentation. So do stay tuned for that. But yeah, as George said, when we were going through the list of attendees, we were delighted to see so many friends, old and new. And to those of you with whom we haven't had the pleasure of working with yet, welcome. We are very, very glad you're here. So when a nonprofit works with an influencer, this type of collaboration takes a very different form than influencer campaigns in the commercial context. Nonprofit influencer arrangements, be they fundraising campaigns or sponsorship activations, other mission-related campaigns and PSA announcements, those activities, as well as other lobbying aspects or even election-related activities, depending on obviously what kind of tax-exempt organization you are, all look a little different through this nonprofit lines. And so all of these considerations are really built on top of, or maybe in parallel to the Federal Trade Commission consumer protection rules. So it's kind of giving you a brief flavor of what we're going to go through. We'll get to the political law and consumer protection issues with help from Shahin and Dave. But when it comes to nonprofits, I think it helps to start with the more basic threshold question. What kind of activity are we asking this influencer to engage in? Whoa. And what core nonprofit legal regime should your organization be thinking about before starting this type of collaboration? So let's kind of kick it off with a couple of, what this might look like. An influencer post that says, learn more about our mission, or a post that says, donate today, or buy this product and a portion of proceeds will benefit us. A post that says, call your legislator. Those all may look similar on Instagram or TikTok, but from a legal standpoint, they are very different. In the context of working with influencers, some of the big topics that I think we ought to consider are, first, preserving your tax-exempt status. You might also be thinking about UBIT, whether to avoid it or to smartly build it into your strategy. There's going to be sponsorship and commercial partner activity and fundraising. So in short, it's helpful to it's helpful to classify the campaign before you begin drafting or finalizing your agreement with the influencer, before you begin preparing marketing materials, and definitely before you go live, because this is going to drive the rest of your legal review. Regardless of whether your organization is a 501c3 public charity, a 501c4 social welfare group, or another type of tax-exempt organization, I think the first and most important thing is really thinking about preserving your tax-exempt status. So to this end, your organization really should be able to articulate how the influencer campaign furthers your exempt purposes. It doesn't mean that every post needs to sound like how you've described your tax-exempt mission to the IRS, obviously, but there really should be a real mission connection. You should be able to clearly understand whether you're hoping an influencer will raise awareness about your organization's charitable work, or if they're helping you reach a new and relevant audience in a way that will help expand your charitable reach. Other ways that they might help might be, supporting fundraising for an exempt program, like I said, or even attending a mission-related event. In all of those cases, we want to make sure that there's alignment between, the influencer's mission, and your own organization's tax-exempt purpose, at some fundamental level. Building off of this, we want to keep an eye out for private benefit. Influencer campaigns inherently provide some benefit to someone, right? The influencer may be paid, or corporate sponsor may receive visibility, a platform may process donations. That's not automatically a problem, obviously, but for a tax-exempt organization, we want to make sure that any private benefit is incidental, both qualitatively and quantitatively, to your organization's exempt purpose. And any other sort of corollary benefits, the influencer or others, really shouldn't be the driving force or real purpose behind the campaign. So, for example, we want to make sure that we're establishing or documenting that no more than fair market value was paid to an influencer. Is the fee commercially reasonable for the defined services? You really should be able to support the rationale for the payment. What services are provided, what deliverables are required, how is the compensation determined, and why does the arrangement benefit your organization? An important undercurrent here, though, is that influencer campaigns naturally benefit the influencer. Obviously, they generate content, they generate visibility, there's audience engagement. Your charitable brand or your nonprofit brand may even lend more credibility to the influencer. In a lot of ways, that sort of incidental benefit is expected, but the balance can shift if the campaign is structured, mainly around the influencer's personal platform or their merch or events or some sort of monetization strategy that they have. We want to make sure that sort of we're taking in the whole picture when analyzing these private benefit issues. But private benefit talks about money going out, right? What you may pay the influencer to help with your campaign. But what about money coming into the organization? We should also be thoughtful about restricted funds, restricted grant funds, for example. If a grant was provided for a specific program, we want to make sure that we're confirming that the money, can be used for influencer marketing, and that it's within the scope of your grant. But pre-campaign exercises like confirming alignment with your tax-exempt mission or ensuring the activity is even allowed sound a bit academic, I suspect where a lot of you really start to pay attention is this issue of taxes and avoiding taxes that incur unrelated business income tax. Even if your organization is comfortable incurring UBIT, and many of you are, we should at least have a couple of guardrails or an understanding of these guardrails so that you don't cross into advertising by accident. So when we think about corporate sponsors that support your organization, a major issue is determining whether the corporate sponsor's payment qualifies as a qualified sponsorship payment, or whether some portion of it is properly treated as advertising or another substantial return benefit. The tax rules provide that the term unrelated trade or business does not include soliciting and receiving qualified sponsorship payments. Qualified sponsorship payment is generally a payment made where there's no arrangement or expectation that the payer will receive any, quote, substantial return benefit other than the use or acknowledgement of their name or logo or product lines in connection with your activities. Permissible use and acknowledgement can include, basically it's high level, sort of a thank you to the sponsor, their biographical information and other value neutral descriptions or displays of their name, logo, maybe product lines, things like that. But use or acknowledgement does not include advertising. Advertising is a substantial return benefit, and that includes qualitative or comparative language, price information, and the like. So when we look at the intersection between nonprofits and influencers, the concern most often arises when a nonprofit, or rather an influencer working with a nonprofit, starts making promotional statements like, use this company X's product, or I found out that company X supports this nonprofit and I switched to them, so should you. Influencers are naturally promotional, and that's why they get hired. But that same style can create problems in this context. So if your nonprofit intends for an influencer to simply provide sponsor recognition, they may have sort of a natural inclination to, put their flair on it, add personal endorsements or discount codes, say things like, company X is my favorite, or they're the best. So when we're working with influencers, we do want to make sure that we have a good handle and control over what the influencer plans to say. All right. Corporate sponsorships are definitely a big revenue driver, but there are broader public-facing charitable fundraising issues that really are key here. And, I think this might actually be the most nonprofit-specific issue that comes up when working with influencers, or at least from my perspective, this is the one that I see most often. If an influencer is simply raising awareness, that's one thing. But if they are asking you to donate, click through to a donation page, encouraging supporters to participate in a fundraising challenge, we really do need to be thinking about the charitable fundraising rules. Charitable fundraising rules regulate not only charities, but third parties who solicit on their behalf. Often for compensation. So depending on the structure of the campaign and how you're working with the influencer, we may well need to think about professional fundraiser rules, fundraising counsel, and similar categories. This can be an easy issue to miss because even though the campaign may look informal, and in fact, it's probably designed to be that way, you really do need to have sort of a pause to think about, are we simply asking for general awareness content, or is the influencer being paid to facilitate this fundraising? And dovetailing on that, because most influencer work happens sort of in the online space, online fundraising can create a multi-state solicitation issue because obviously social media campaigns aren't confined to any one jurisdiction. So to that point, your organization should really be thinking about whether the campaign is specifically targeting residents of a particular state, whether contributions received from those states are received on an ongoing or repeat basis, and really whether or not the campaign is going to create enough of contact with the state to trigger that state's charitable solicitation requirements. So again, it's not only your organization's charitable fundraising compliance perspective, but the compliance considerations that your influencer needs to work with. You know, when we're dealing with social media platforms, we also want to be careful with who's legally responsible for fundraising activities happening there. So when you're setting up this arrangement, we want to make sure there's clarity on the custody and control of funds, including, very importantly, whether fees are going to be deducted from donations raised via a particular campaign. This is going to affect what the influencer may be able to claim. We'll have to be very careful with things like 100% goes to charity if in fact contributions are deducted fees are deducted from contributions in some way. So suffice to say that just because there's sort of a casual or authentic donation ask doesn't necessarily mean that your organization falls outside of charitable fundraising rules. And with that, I made reference to claims, 100% of donations raised and things like that. This can be a place where fundraising appeals can take on a little bit more risk. Influencers are effective because they communicate with their audience in a way that is direct and emotionally compelling. That's valuable in marketing, but it may also lend itself to being either overly simplified or maybe even embellished for purposes of fundraising messages. And this can create legal or reputational issues for your organization. We want to be sure that saying things like, every dollar feeds a family, is that too precise? Can your organization substantiate that sort of cost per family claim? If they're going to say something like your gift will be matched, well, we need to make sure we have the backup to support that. Is there actually sort of a major donor behind a campaign? You'll want to explain the terms and things like that. And Shahin will definitely get into that in a moment. But sort of putting a slight twist on this, I think be careful when it comes to campaigns that are direct responses to disaster relief or emergency responses. These campaigns can be emotionally charged, and it's very easy to veer from a script if an influencer feels like an off-the-cuff remark is going to feel more natural. So if your influencer says that funds are going to be raised for a very specific purpose, your organization really does need to be prepared to honor that restriction. Otherwise, prior to the point of completing a fundraising transaction, we need to be sort of careful in setting up arrangements to protect your organization from having funds received that are too narrowly restricted. As I mentioned, we'll talk about sort of the content of your agreements with influencers in a bit, but it is good practice to give influencers pre-approved fundraising language. Have this language explain the donation ask, any restrictions, matching terms, fees, sort of any sort of material terms. Obviously, we want influencers to speak authentically, but the core legal claims really do need to be controlled. Another area where nonprofits should be careful is with respect to cause-related marketing activity and CCV or commercial co-venture activity specifically. These are very easy for influencers to promote. Buy this product and X amount goes to your nonprofit. This is a very effective tactic, but it also raises specific legal considerations. Most states regulate CCVs in some way, shape, or form. The basic concept is that, when a person advertises that the purchase or use of goods or services will benefit a charity, that will sort of trigger these CCV or charitable sales promotion rules. You'll want to make sure you have a written agreement in place with the influencer or the company behind the campaign with clearly defined geographic scope, a clear donation formula. We want to avoid things like net proceeds will benefit the charity and sort of stick with more specific donor identifiable metrics and things like that. So this is definitely another area where your nonprofit should be controlling language, controlling the agreement, and we don't want to improvise the donation formula in any marketing assets issued by your nonprofit, issued by the influencer. All right. So let's wrap up, I guess, this overview from the nonprofit perspective with a few practical controls to have in place before launching an influencer campaign. You'll want to, as I've sort of been hammering home, use a written agreement, particularly where a campaign involves charitable fundraising. It needs to go beyond simply saying that the influencer will comply with applicable law. We really do want to describe what it is the influencer is being asked to do, how they're going to do it, how they're going to be paid. Again, if they're going to be paid a portion of funds raised, this very well may prompt you to think long and hard about whether that's the best structure, because it could raise professional fundraiser compliance considerations, or if you're really better off sort of coming up with an alternative arrangement for your influencer. I would say that, when influencers are paid a percentage of funds raised, this can create incentives that may not be aligned with your careful messaging. They may be motivated to, again, make the most compelling ask possible. So this all kind of is different perspectives on really this central issue of maintaining control of that. But speaking of maintaining control, you'll want to, wherever possible, make sure that funds flow directly to your organization. This pathway matters a lot and can often protect the organization, or at least put you in the best position possible. It also gives you the best vantage point when needing to negotiate if fees will be deducted through any platforms or the like. Finally, and I'm certain Shahin is going to get to this in a moment, but we want to reserve the right to correct or request takedowns. And that's especially true where your tax exempt status, may be implicated. Yes, inaccurate fundraising claims or sponsor language may sort of veer into advertising in a way that could raise you bid. But all of these really suggest that your nonprofit needs the ability to react quickly when you do see the need for a practical correction. So in short, aligning on marketing assets and memorializing key terms in a written agreement aren't just nice to haves. They're sort of essential to your nonprofit's compliance structure. And this will help you, reduce the risk that any informal social media campaign ends up inadvertently creating formal legal consequences for you. So with that, I know we're not quite at the 30-minute mark, but this might be a good place to introduce the CLE code. So today's CLE code is Influencers 2026. No need for any particular capitalization. Again, that's Influencers 2026. So with that, I'll turn it over to Shahin.
Thanks, Cristina. The name of the game in terms of what I do is Federal Trade Commission and State Attorney General consumer protection, false advertising type issues that even if you are a nonprofit that you need to be aware of. These are laws that are enforced by the Federal Trade Commission generally, but as well as guides as well. So moving forward to the next slide, you can see that the FTC's doesn't have authority to regulate entities that are nonprofit, that are specifically nonprofit. Its authority only extends to entities organized to carry on business for its own profit or that of its members. There was a case back in 2025, however, against Grand Canyon University, which was a university that was nonprofit, and the FTC targeted that company for its, I'll use the word fundraising efforts, its money-making efforts to generate revenue to pay for expansion and self-perpetuation. And in that case, the court looked at that and said that's a true nonprofit. This is true nonprofit activity, and we're not going to regulate the advertising there. But organizations can't merely claim that they're not profit to avoid regulation. And the FTC has on many occasions reached organizations seeking a private benefit, including where you have dividends to owners and investments. And what Cristina said earlier about making sure that when you're engaged in certain activities, that it is a true not-for-profit purpose. These are the types of things that a court will look at to see whether or not the FTC Act state mini FTC acts will still apply. And as you see here on this slide as well, state regulators and courts will still look at FTC guidance to interpret other false advertising and consumer protection laws that will apply to nonprofits. In other words, although we're going to talk today a lot, or what I'll be talking about a lot today, is the FTC guide concerning endorsements and testimonials and what they say the FTC says about influencer marketing. Those will apply in certain circumstances to nonprofits, but particularly will be applied on the state side. And even if you're challenged for general rules surrounding your activities and what you're saying and how you're doing it, you will still, a court would probably still look to the FTC guides to see what is, what is right and what is wrong. And here, if you can see on the next slide about a study that was conducted on the importance of transparency in advertising and promotion. And there have been a couple of studies regarding what people think about when they see, I'll use the word influencers or content creators, when they see somebody who is out there posting about whether it's an organization or a for-profit company. There's a question about whether or not the message loses its legitimacy or you lose audience trust based upon the speaker, the fact that they're saying this on behalf of somebody else. And you can see here that in 2024, nearly 50% of nonprofits advertise through influencers, which increase their fundraising capacity, issue advocacy, as well as their legal risk. Then last year in 2025, the Better Business Bureau conducted a survey of the audience about influencers, this time being more focused on the for-profit side, and found that the mere partnership itself isn't what drives distrust. In other words, I'm not going to lose trust for so-and-so influencer who I follow simply because she is now partnered with a nonprofit. But what that study did find was that if somebody thought that influencer was hiding that partnership, if there's some sort of subterfuge that's occurring and there is a message that they're promoting, the influencer is promoting with somebody, but they're not disclosing it, that is what triggered the mistrust or distrust. The one thing that I will say here on this slide is this idea of lack of disclosure. I'm going to talk a lot in my portion of the webinar about disclosures. When's it required? What does it require? What do you have to say? How do you have to say it? But I want to caveat this by saying that we're sitting here on May 28th, 2026. This is going to be posted on the internet afterwards. You'll get the slides later. This can change. One thing that, even though we have had studies here about whether or not you have trust or distrust based upon the fact of a partnership, we are sorely missing studies on what people understand with respect to influencers and content creators online specifically. I've asked the Federal Trade Commission, I've asked the National Advertising Division in conversations with them, I've asked state attorneys general, plaintiffs' attorneys, what evidence do you have? What consumer perception evidence do you have supporting your position that this disclosure needs to happen in this place and that? And the reason I'm saying this to the audience is because I will set forth what the guidelines are today, but that's not to say that that's not going to change based upon court's interpretation once we do get survey evidence, once we do have courts ruling on these things. We do have a lot of questions in the chat. I'm going to try to get to as many of them as I can about specific use cases and circumstances. But one of the reasons I'm saying this is because this is a very squishy area, and what to disclose and how is something that I do believe will change once we have more evidence and court decisions in this area. So going on here further to the FTC's updates to its endorsements and testimonial guides. I started here by saying that the FTC's endorsement testimonial guides are going to be what drives the legal requirements surrounding influencer marketing and what you have to say, how you say it. I want to also caveat all of this by saying that the FTC's guides are just that. They are guides. They do not have the force of law. It is not as though the FTC can go in and say 16 CFR 225 is a law, and therefore a violation of that is a per se violation of the FTC Act. You owe me money. The reason for that is that it's not a trade regulation rule. However, the FTC will look to its endorsement and testimonial guides as persuasive authority to show that if a company or a nonprofit is violating those guides, then it is it's basically aware of what it should be doing, and the FTC has promulgated these guides for a reason, and therefore a violation of those guides really demonstrates a violation of the FTC Act. So The FTC initially published the guides back in the 1970s. This was really around the time of television advertising and content, but it's updated the guides a few times, including in 2009, most recently in 2023. And the most recent versions of the guides have really focused on online content creators and influencers. And the FTC has also issued a number of FAQs and guidelines for influencers, 101s for influencers as well. So there's a ton of guidance online. We have the links here, but if you also have questions about additional guidance, feel free to reach out to us. And moving forward, we can talk about the specific requirements under the FTC's endorsement guides. Those requirements are that the endorsements must reflect the honest opinions, findings, or beliefs or experience of the endorser. An advertiser, and I'm going to use the word advertiser because that's what the guides use. I know that that's probably not exactly the word we would use to describe ourselves here, but an advertiser may continue to use that expert, celebrity, or endorser only if the advertiser has good reason to believe that the endorser still believes the views that are presented. The endorser has to be a bona fide user of the product at the time the endorsement was made. Again, this is something that doesn't specifically fit one-to-one with nonprofits and issue advocacy. But what it does mean is that you can't go out and pay somebody who doesn't share the views of what they are stating or claiming in their ad. If you have somebody who's on one side of who has always voted for one political party, and for whatever reason you have an issue or a campaign that you're using them for the other, that's going to be something that's viewed very with a lot of scrutiny. And I will say that in this current environment, even though the FTC's technically has limited jurisdiction, I would do my best as a nonprofit to comply with all of these requirements because we don't know what a court would do. The challengers are all out there. There's a lot of political issues that are hot button issues. People tend to be more aggressive. And, my advice to clients generally, no matter where you are, even if you have technical arguments, even if you can argue somebody doesn't have jurisdiction, the more you can say they don't have jurisdiction, but even if they do, I'm complying with all these requirements, the better position you're in and that we as outside counsel can use to defend you. Now, the two major issues with influencer marketing are that you need to disclose material connections. That influencer, the speaker, the content creator who's out there publishing content needs to disclose the material connection between the speaker and the sponsor. Material connections include things like payments, free gifts, employment, a free trip to a fundraising event. That was one of the questions. Those need to be disclosed when a significant minority of the audience for an endorsement would not understand or expect the connection. The idea here is that an unexpected connection must be disclosed. Now, I tell clients to read out that unexpected idea. You should assume that anybody who is viewing the content online or elsewhere, unless it's incredibly clear that this person is associated with your organization, they should disclose within that content. And we've seen cases where Kevin Hart, who has an ownership interest in, I think it's Fabletics, got in trouble for not disclosing his relationship with Fabletics, even though I think it's incredibly clear that when Kevin Hart's talking about something, that he's going to have some sort of connection or reason for doing it. The endorsement needs to clearly communicate the type of the connection enough for people to evaluate the significance. I think that we have a lot of flexibility here. You don't have to say I got paid $1,000. You don't have to say I'm the VP of communications of the organization. That's my connection to the organization. So complete details aren't required, but enough really to put somebody on notice. The idea being that it might impact the credibility or the weight that somebody is going to give to the statement that's being made. So what do you have to disclose? Any material connection between the advertiser and the influencer. So we've gone through the payment and the free products or services and the travel. Another thing that people don't often think about will be the sweepstakes entries. If you're entering people into a sweepstakes for something, then that would be something of value. If you're donating on behalf of somebody to an organization or somehow using that allocating funds in that way, even if they're not going directly to the speaker, That would be another thing that needs to be disclosed. Any type of like employee relationship, business, family, or other close relationship. In the nonprofit area, I get a lot of questions about volunteers. I think this is a very sticky one because I think if somebody is a volunteer, then inherently they're not really getting paid. But there's an argument to be had that there is a material connection. So disclosing that, I always say err on the side of over disclosure, and particularly when you're looking at issue advocacy or nonprofits that are issue oriented, then think about it. You want to lean into that connection. I partner with this entity because of this. I believe in it. I volunteer. I volunteer every weekend. I mean, those are things that to me are almost, you're using that disclosure in a way that's more impactful. It's amplifying the message and it's amplifying the connection in a way that is really building trust and building credibility all across the board. So employees should disclose too. That is, that's something that the FTC says. It's pretty clear, and I think you could use something similar to what I just said, which is really leaning into the fact that you're working for a nonprofit. People who work for nonprofits tend to really be, believers in the causes, and so I think that again is something that you shouldn't shy away from. And if you do have a policy about communications, including language in your policy about communications to whether it's your employees or to your volunteers, explaining what they're permitted to do when they're talking about the organization in social media and publicly, because otherwise you could get very sticky. There's some also really requirements about how much you can restrict employees' languages too. So don't just go out and go hey about what you write in your manual. That's something that I recommend having reviewed by attorneys. We have some folks here at Venable that I always have take a look at that before we go too far about making policies there. There were some changes to the FTC guides in 2023, and these are the changes. Now, one of them is that an endorsement explicitly includes a tag in social media. In other words, if somebody is out, if you have a picture of me at a charity event, maybe it's a charity 5K, and I'm saying, hey, I just finished my 5K for XYZ nonprofit, and I tag that nonprofit, and I happen to be an athlete. I am not a good one, but if I were, then I tag them, then that would be something that the FTC guide says that's an endorsement. And now because it's an endorsement, because I have some sort of connection, if I'm being paid, then I have to disclose it in the way that I just talked about. The FTC guides also talk about AI or CGI influencers. This is something that is starting to happen. I don't know that the nonprofit side uses this as much, but if there are virtual or AI entities out there that have large followings that you want to work with, I suggest doing that with extreme caution, because an AI entity typically can't adhere to a specific belief. And so to the extent that in order to be a truthful representation is that this is a true person who adheres to a certain belief, it's very difficult to do that if you're an AI entity. I'm not saying it's impossible. I'd love to see, there are a lot of these issues I would love to see litigated, but for now, I say proceed with extreme caution. A product could include not just a product or service, but now they're saying a brand, company, industry. I don't think it's gone so far to say a specific cause, but if that cause is tied to your organization, inextricably linked, that the discussion of the cause is such that somebody's going to know exactly that that person is talking about you, then if that's your influencer, I would say you want to look really carefully about what they're saying. Go back to the scripts, as Cristina was talking about, to say maybe you don't want them doing that. Maybe you want to make that connection very explicit. Either, don't be on the fence about whether or not they're endorsing the cause versus endorsing you. Really lean into it and follow all of the requirements. Liability has been expanded. The FTC is always looking to expand the people it holds liable. I generally tell people that if somebody's going to get in trouble, if it is the influencer, you should assume that you as an organization are going to be brought in, or vice versa. So influencers should not say, oh, hey, I'm just John Doe, I'm just a person, you're not going to sue me. The FTC will go after influencers. They love to go after people. Using of someone else's image, like a stock photo, with a testimonial can also be deceptive. One of the things we're seeing a lot of are AI enhancements or AI generated images of people that are overlaying with things that is a testimonial of a human person. That's something that the FTC will regulate in some ways. If, for example, the image of the person is conveying a standalone claim about the organization or we also have some disclosure requirements in states like New York if you are using an AI generated image that appears to be a person. And then the disclosure when the material connection is required, it now requires that when there's a significant minority of the audience that wouldn't expect the connection. As I mentioned earlier, this really hasn't been settled when somebody doesn't expect a connection. So my recommendation is always to just assume that it's not expected and move forward. How to disclose. This is very, this is still a lot is out there. So it needs to be clear and conspicuous. The disclosure has to be unavoidable is the name of the game. So not after a hyperlink, if it's on something like a Facebook or Instagram ad before somebody has to click see more. If it's in an image, it shouldn't be overlaid in small text that's difficult to read. Basically, it needs to stand out. It needs to be easily noticeable, easily understood. When you're looking at disclosures that work, on the next slide, you can see that you can use really plain words, things like ad. They don't sponsored is another one, I think. I like it says avoid ambiguous tags like partner or ambassador. I think that you can use things like partner with or nonprofit organization partner or ambassador for the nonprofit organization. I think there are ways to do that because it's difficult really to say that somebody doesn't understand the connection when you're linking those two together. And I've had the National Advertising Division, which is an organization that reviews advertising and adjudicates advertising disputes. They have said that as long as that language is clearly distinguishable, that it is company partner, as opposed to just partner, then that would be something that they would accept as sufficiently clear and conspicuous. And on the next slide, you can see an example of what not to do. This was somebody about a decade ago who he used video games, and I guess he was an influencer. People love to watch him play video games. And he did not disclose his connection. He was getting paid by the seller of the video game. And you can see down at the bottom, it says this video is sponsored by Warner Bros. And it says no one reads this far into the description. What are you doing snooping around? I mean, that's evidence that the guy knew what he was doing was wrong, because if the disclosure needs to be clear, conspicuous, unavoidable, he's literally telling people, what are you doing looking so far down here? Nobody reads this far. And this is where I'm going to disclose, meaning I know that nobody reads this, and this is where I chose to disclose. I mean, I think I wouldn't want to be the one defending that lawsuit, and that one did settle. Probably part of the reason was the optics there. But here on the next slide, you can see an example of a nonprofit influencer post here for the United Way. And in this one, you had a woman who was talking about United Way, talking about how they were helping and what they were doing. There was a link, there was sponsors, there was a link up there, there's branding. Let's make a difference together this Giving Tuesday. So I think this is one where you have those disclosures. I think those disclosures could always be better. And there's, I think this is an example of where you would have something that really insinuates the disclosure, this language like together, when you have branding all over it, when the speaking is talking about her connection there. Of course, you could just say sponsored or partner, but I think that there's ways to make it a little bit more creative, and particularly when you're doing a voiceover and you're speaking to discuss that connection. I think we can move forward actually to the importance of monitoring and enforcement. And one of the things, Cristina was talking about this earlier, is making sure that your influencer agreement is really buttoned up. We'll talk about some specific provisions. Those establish the terms of the relationship as well as compliance. It's something that's very easy to point to in a challenge. Hey, we had this language here. If there is a challenge, this is what we told them to do. As Cristina said earlier, don't make it super broad. Oh, thou shalt comply with the law. That's really not enough. When regulators look at this, they want you to be more specific, comply with the endorsement guides, and I would say be a little bit circumspect about how you do it. I would say comply with all applicable laws. And then you could say, if you need guidance on how to disclose, the FTC's endorsement guides provide that guidance. Because what you don't want to do in the contract is admit, for example, that you are subject to the FTC's guides. So be a little bit intelligent about the way and deliberate about the way that you're including that language. And you can also just provide the disclosures and the provisions themselves of the 16 CFR 455, as opposed to just saying comply with all the Federal Trade Commission rules when we later want to say that we're not subject to those. What the FTC also wants to do is make sure that you're monitoring and enforcing what you have in those guidelines. Don't just tell an influencer, hey, okay, we're going to pay you for 4 posts, go out and do it. And then you've told them on the front end, hey, you need to disclose a connection here. They don't do it. And then you just don't take any action when they've gone out and violated those. So some best practices for social media influencers here on the next slide are having those standard contractual terms, including a training program if you have enough. Provide them training. The other thing to do is record some training and then just show it to influencers. We've done this for companies that have really large influencer programs as well. Give them do's and don'ts. Give them guidelines. Maybe it might be a script if you do have a high profile campaign, but it might also be more guide rails. Influencers are people too. That's why they have a following. And so they don't, they can only stay so much within the guide rails. So providing them with brand messaging and guidelines about what they say and can't say can go a really long way. When you're looking at influencer agreements, on the next slide here, you can see some things to include making sure that you have who is the parties, what's the length of the contract, particularly if it's exclusivity. If this is an influencer that's not just for your nonprofit, but also for other issue organizations or even for profits, you want to look really closely at exclusivity. The more exclusive, the broader the category, the longer the time you're going to have to pay for that. Typically, when you're looking at influencers, looking at the compensation and payment schedule, I would say be careful about paying things completely up front, because once you pay an influencer, oftentimes they're not as receptive to responding to subsequent requests. Making sure that you do have approval rights, procedures, and takedown rights, that if somebody gets something wrong, that you have the ability to take that down. Who has the right to use the content, making sure that if you do want to reuse it, that you have that right, especially in print materials, because sometimes you don't have that right. Make sure that you have language surrounding AI, starting to see that where people want to enhance content using AI, and either they don't want to allow you to do it or you don't want them to do it, having that there. Morals clauses. We're starting to see language that says not only the influencer can't do anything that brings us into disrepute, but they want it to be two-way now. So if you do something that goes against the influencer's beliefs, that they can terminate that agreement as well. And, I've had different schools of thoughts on it, but some influencers this is a hill they will die on. So being prepared for that and just writing it carefully. The last point here, indemnity clauses. A lot of times we tell clients, look, the indemnity clause isn't worth the paper it's written on, but having that indemnity clause is good, because if you do get challenged, it gives you the opportunity to cross-claim against the influencer, even if you're only going for $1. The reason being, it allows you to put your statements in front of the court earlier, rather than waiting until much later in the proceedings, because you can't put facts in front of a court on a motion to dismiss. And I think we'll just breeze through these slides really quickly just to give you sort of high level. Make sure that you're training everybody, documenting attendance, document all of your compliance efforts, including any lists that you're providing. The next thing to do is to monitor, which make sure that you've designated who's going to monitor, set up check-ins, document the monitoring, and take enforcement action, as you can see here on the next slide. Contact the influencer. There need to be real consequences. You can't just send the influencer 10 emails and then not do anything about it. And document that. Again, when you do have something that goes wrong, document it. So having a crisis response plan ready. If you have really big campaigns, be ready. Let them know who things need to be escalated to if something goes wrong. So with that, I'll let David take it away with the lobbying and election issues.
Hi, Shane. So, shift here from kind of the FTC and consumer protection framework to a different but really equally important set of considerations when you're working with influencers and content creators on issue advocacy and lobbying, and that's kind of the campaign finance, tax law, and other kind of considerations to keep in mind. Nonprofits are really increasingly turning to social media influencers, not just for fundraising or brand awareness, but also to amplify policy messages or mobilize grassroots action and shape electoral narratives that are important to their organization's mission and purpose. And so when you're moving from the commercial advertising into the policy and political space, the legal landscape really changes quite a bit. The FTC endorsement guidelines Shahin talked about really focus on commercial advertising and endorsing. But when influencers are engaging in advocacy, lobbying, or election-related speech on behalf of a nonprofit organization, you need to think about a different set of rules, right? So we're talking tax law, lobbying disclosure, campaign finance law. Then you also have to keep in mind transparency expectations and reputational risks. And so, while the federal campaign finance and lobbying rules may not always require on-post disclaimers, particularly for organic influencer content, that analysis can really change if an influencer is making communications to support exposed candidates or ballot measures. There are also state-specific laws or platform policies to keep in mind. Let's start with the key tax law considerations to break down that framework and how it applies when an influencer is working with your organization and is communicating about public policy or political issues, are really four categories of activity to keep in mind, and where your influencer's content lands will determine your own compliance obligations. So first, we've got education and issue advocacy, right? So these are really communications about public policy issues that might be important to your organization and don't amount to lobbying or supporting or opposing candidates or political parties. So, example, an influencer might talk about why affordable housing matters or why civic participation is important. If that content stays focused on the issue, doesn't ask the audience to contact legislators, support or oppose legislation, a ballot measure candidates, generally stays in the issue advocacy and educational lane and won't be treated as lobbying or campaign intervention. So that's really the safest category from a regulatory perspective. Then we've got lobbying, and you got direct lobbying, which involves communication with legislators or their staff about specific legislation, combined with a viewpoint. Importantly, here it's a key nuance. Ballot measures are treated as legislation are for tax purpose. So if an influencer is urging people to vote yes or no on a ballot measure or ballot initiative, that's lobbying expenditure for tax purposes. It's not campaign intervention, even though it involves an election and may still be regulated by state or local campaign finance law. And third, you have grassroots lobbying, which is a little distinct from direct lobbying because communication is aimed at the general public rather than legislators themselves, right? And the key difference there is that the communication has to contain a call to action, right? So you've got asking the audience to contact their legislators about specific legislation. That distinction matters a lot, obviously, in the influencer context because influencers, by definition, are going to be talking to the public. So when we're talking about lobbying, grassroots lobbying is most likely to be triggered by influencer content when they're talking about legislation. Then finally, campaign intervention. That basically means the communications about supporting or opposing candidates or political parties. Of course, for 501c3 organizations, this is absolutely prohibited. So it's really a bright line to keep in mind. The challenge really with influencer content is that the lines between the categories can blur quickly, right? So um, imagine you've got an influencer who posts a video about an environmental bill and then kind of explain why it matters and it's important. Then the last 5 seconds says, you should call your legislator about this, right? So that last sentence just converted what was really an educational communication into grassroots lobbying. Or you might have the influencer post content about that same environmental bill, identify a legislator by name that's opposed to it and say, listen, we've got to vote them out in November. And now we've got campaign intervention, So, um, talk about how you mitigate some of that risk and keep them on the right side of the lines here in the next slide. Um, Answer starts with clear and practical guidance that you build into your issue briefs and your agreements. And if you're working with an influencer, you might consider providing creators with a very simple do's and don'ts list, right? So if your organization wants to avoid lobbying, no outreach to legislators, no calls to contact lawmakers, don't identify a legislator who's going to vote on legislation that's being opposed to or undecided about a particular view in the legislation. Instead, focus on audience education, right, and help provide facts and improve the public's understanding of the issues. You want to stay educational, use facts, neutral tone, a full and fair explanation of the issue. If you're going to try to avoid political activity, then that list should explicitly say no candidate, party support or opposition, no election or voting references, no coordinating with campaigns or using materials that are produced by a campaign, and no political fundraising asks. So one of the key takeaways for this slide is that the classification will really turn on what the influencer actually publishes, right? So it's not just the contract terms or your organization's intent, and you've got to be careful because even if you have the best agreement in the world, if your influencer goes off script and puts out content that crosses into lobbying or campaign intervention, that's really where your risk lies. Because the IRS is going to focus on what was published in the surrounding circumstances, not just your contract terms or organizational intent. I'll talk a little bit here about tracking and expenditure reporting. From a practical compliance perspective, your organization needs systems to track influencer costs by activity when we're talking about lobbying and campaign related activities. So you've got to break your expenditures out into education, lobbying, ballot measure activity, candidate related activity. And why? Because your lobbying expenditures may need to be disclosed on Form 990s and Schedule C. There may be state and local lobbying disclosure rules that apply as well for 501c4 and C6 organizations. You'll also need to track political campaign intervention for Form 990 disclosure purposes and potential 527F proxy tax exposure. Um, and don't forget that agency and influencer payments themselves, depending on circumstances, may be reportable under federal, state, or local campaign finance or lobbying laws. So it really makes sense then to preserve your influencer content and your spending records, so you've got documentation to support your tax, lobbying, and campaign finance classifications if questions come up later. So this slide addresses kind of a nuanced but important point. Even when you aren't legally required to include disclaimers, for transparency may still be the right call from a risk management perspective. Let's start with the baseline. The FTC and FEC disclaimers may not really be required for influencer posts, right? Um, if they're paid boosts, platform ads, or communications that are supporting, opposing, or referencing candidates or ballot measures, that might change the analysis. State law is also an increasingly important consideration. California and Texas, for example, may require paid political influence disclosures. There's been a lot of media scrutiny recently related to influencers working for candidates in the California gubernatorial election this year, and allegations that they didn't apply with the state disclaimer rules. State law may also have disclaimer requirements for grassroots lobbying communications. The platforms may require labels or restrict paid political content. And then individual influencer agencies may have their own disclosure rules that go above and beyond whatever the law says. In addition, you've got reputational considerations. Audiences and journalists are really looking closer at whether influencers that are making political statements are doing that because that's what they believe or if they're actually being paid, right? So undisclosed paid influencer campaigns are really a prime target for scrutiny. And the bottom line is that voluntary disclosure, like when it's not required, can reduce your reputational risk. So keep that in mind. There are a few high-profile instances of influencers leaking contracts that have been working with nonprofits. So always understand that there's a risk that your work may be disclosed, even though the rules don't require it. Close here quickly with some compliance controls when you're working with influencers on lobbying and election related influencer campaigns. And some of this dovetails with what Cristina and Shahin mentioned. First, define precisely whether the influencer is authorized to do issue advocacy only, lobbying, electoral communications, expressly prohibit crossing categories without approval. That needs to be spelled out clearly in your agreement. Before your influencers engage in lobbying or election-related activities, make sure you understand all the applicable laws, depending on the arrangement and how much control your organization is going to exercise over the content. You may need to review to ensure consistency with your organization's objectives and legal compliance. Probably have to consider reviewing higher risk content where that's appropriate. May not need to review every word of every script, and too much control can create its own problems, but scripts, talking points, live stream plans, and especially election sensitive references probably warrant review before posting. But there's some tension sometimes because you have to balance guidance and control carefully. More control of content's not always better. Too little control may create compliance drift. Too much can undermine the influencer's own voice or editorial independence. So you have to keep that in mind. Finally, track your spend by category, as we discussed. And to close it out, really the big picture is that influencer campaigns in the policy and political space require kind of a different compliance mindset. And the legal frameworks are more fragmented. The consequences can potentially be more severe, and the content is harder to control. But if you've got the right agreements, clear guidelines, monitoring, record keeping, nonprofits can work with influencers effectively in this space while managing your risk.
All right, everyone. Well, thank you very much for joining us today. We are a few minutes over, but again, for those of you who are watching today's presentation for CLE credit, that code was Influencers 2026. We know there were lots of good questions submitted during today's presentation, and we will do our best to get back to you all, as we're able to. So otherwise, thank you again for joining us today, and I hope you have a wonderful rest of your afternoon. Thank you.
Thank you.